No surprises here reading through the grounds.
There's one surprise, the first ground.
The first ground surprises you.
Yeah, because it came out on news file. The lawyer hadn't averted his mind to it, even though I told them that it was a contorted distortion contorted interpretation they were putting on Section 46 of the Minerals and Mining Act.
Okay, the one having to do with the interpretation of the Minerals and Mining Act.
No, the one that having to do that in the light of Section 13.8 and 46 of the Minerals and Mining Act, the activities that went to be carried out on his land were reasonably, drawn, or were reasonably incidental to his mining lease, something like that.
Okay, so break that down for us. What was your understanding of what they were arguing?
When you take a mining lease, there are certain things that you can do with the mining lease. You have to mine on the land.
Okay.
You have to reclaim the land and all those things. You have to mine in accordance with the terms and conditions under which you have been granted a license. So if you go onto the mine and you are mining, if you bring excavators onto the land and you are mining, it will be reasonably inferred that those activities are incidental to the lease or concession. But if you bring people onto the land to do illegal activities, how can those activities be reasonably incidental to your lease?
Okay. So
you understand?
Okay.
They're trying to say that what Herichum was doing on the land was reasonably incidental. That's what the section is saying. For the section is saying was reasonably incidental to the concession. What Wontumi was to do on the concession, but the Henry Okum was not lawfully permitted. So his activities could not be reasonably incidental.
Okay. They are convinced that if you apply, is it Section 46?
What is your activities, when you take a mining lease, if you read Section 46 and 13 together, and you take a mining lease, and you are going onto the land, and you are mining in terms of the conditions and terms under which the license has been given to you. Okay, so you have done a tailings dam.
Okay.
You are pumping the water out of the tailings dam. You are treating the water before you are pumping it out. You are reclaiming the land. Those activities are reasonably incidental to your concession.
Okay.
Your permit.
Okay.
Okay?
Yes.
But if you go onto the land and you are doing activities that are not supported by law, those activities cannot be reasonably incidental. And this matter came up on Joy FM. I told them, Joy Newsfile, and I told them that the interpretation they were putting on Section 46 was stretched, was contorted. I told them.
Okay. Is it their argument that the 99 should not apply in this situation?
No, that is the second leg. So they are appealing against the whole judgment. And the first ground was that the judgment is unreasonable because the activities carried out by the first and third accused persons were reasonably incidental. That is Section 46.
Okay.
You get it?
Yes, I do.
And I'm just telling you that 46 came up when Samsolade Ayinini drew the attention of Atachi to Section 46. Whether they averted their mind to that. And I told them on Newsfile that it was a stretch interpretation they were putting on Section 46, and it could not be supported because that's contorted. When they say you're reasonable, when you are a student and you get up and you are going to the classroom and you are holding your books and you go to the library, those activities you are carrying out are reasonably incidental to your status as a student. Okay?
Yes.
If you are a journalist and you're hosting Radio Gold, you get up in the morning, you go to work, you sit on the console, you review papers and all those things. Those are reasonably incidental
Okay.
You understand?
They are part of the work
You
you're
can
doing.
draw there.
Okay.
Any reasonable man, it's an objective test. It's not a subjective test. It's objective. Any person seeing you without asking you know that you are a journalist. They can reasonably be withdrawn from the activities that you are carrying out. So they are now saying that the activities that went to be carried out were reasonably incidental. So they are just closing a straw.
So that's the only surprise for you.
That's the only surprise. The second surprise, I had told them that, well, I don't know why they were even making noise. And you remember I said that the jurisdiction of the court is not invoked by emotional discharges.
I heard that. What does that mean?
That simply means that if the court gives a judgment and you are dissatisfied with the judgment, shouting on top of your voice and holding press conferences and being emotional and calling him cannot invoke the jurisdiction of the court. Doesn't get the court to look at your case. Those things doesn't get the court to look at your case. You must take the proper steps. You get it?
Yes. And I guess they listen to you and they've taken the steps.
Yeah, they listen to me. They have taken the steps. So they stop talking and take the steps. And I told them, if you think that Article 1911 of the Constitution has been breached, because the offense for which Wontumi has been tried on has not been defined in a written law, or the sanctions or the penalty for that offense has not been prescribed in a written law, and that the court substituted his own idiosyncrasies for the written law. That's a fundamental right. That's a fundamental right. So whether the court ruled against you or not, it's an appealable ground. Whether the court refused to state the matter or not, it's an appealable ground. Because it's a fundamental right of the person. Okay? And so they have also put it there. And I think that they will stop the noise and go and pursue their appeal. Thank you.
We lost you there. Sorry about that. And on, I think you are on the matter of interpreting the provisions, because that's one of the things
so
they're asking
on the
for
matter of Article 1911, which is part of the Chapter 6 of the Constitution and deals with fundamental human rights and freedoms, and says that a person cannot be punished for an offense if the offense is not defined, and cannot be sentenced or penalized if the sentence is not prescribed in a written law. So that's section Article 1911, and they're arguing that the combined reading of section 14 and 99, particularly 99(2)(b) of the Minerals and Mining Act, as amended, that's Act 995, doesn't seem to define the offense. And I told them that yes, that's your argument, then you don't need to make noise. Just go to court and argue you out, because your continuous description of Wontumi as a political prisoner and all that will not invoke the jurisdiction of the court. It will not get the court to relook the case. You understand? But I also told them that apart from the long line of cases that the judge cited, the Quality Grain case also came up for such consideration when counsel argued that Section 179 of the Criminal Offences Act, which codified custom financial laws, did not define what financial laws is. And so when lawyers for the accused persons raised this matter before Justice Afre, the late Justice Afre, he said he will address that in his judgment, and that they should continue with the case. And in the judgment, he even went to Blackburn Dictionary to define financial laws. He said that everybody knows financial laws. And Kwan Pepra, Sipayanke, Adam Ibrahim was sentenced to a term of imprisonment.
I see. But I thought they were applying at Section 99(2) of the Act.
Yes.
And if you read it, it's clear on the sentence range.
Oh, but we all know it's clear. Then see it's not clear. So again, they are using their own idiosyncrasies to put an interpretation on Section 99(2)(b). That is why the court will have to look at it and see whether there's merit in what they are saying.
I see. Very interesting. And I know at this point, but what's your assessment of everything they have taken to court?
So far, the grounds on which they have gone to court do not appear to convince me that they will be able to overturn the judgment.
Not convincing.
Mm-hmm.
Not even the fact that they say no reasonable person would read the judgment and be convinced.
The reasonable person test is objective. It's not subjective. It's objective. So it's not. That's why I said idiosyncrasies. It's not. It doesn't depend on how you see it. It depends on what the common man at the trotro station at Tudu Loro station, Loro Park, will think that means. It's a reasonable man's test.
I see. Before we learn, just some education on what happens next. They filed this appeal. So what happens? Do they have to convince the court that there's a reasonable ground of appeal? What do they do?
So that's the first. They triggered the process. So the next step they will take, and I'm sure they will take that step, is to apply for bail pending appeal. They will also have to go to court to settle the records. Settling the records just means that they have to go to court to agree on the matters that should be part of the record to be transmitted to the Court of Appeal.
Well, I'll be looking forward to all that. Alhaji, thank you very much for speaking to us this morning.
You're welcome.